Yeah, thanks very much for coming, everybody, and I'm very grateful for this opportunity to give a talk this morning. I'm going to talk about some research I've been doing and how open access helped to get more dissemination and diffusion of the research. But let me begin by saying a bit about myself. I'm a legal academic and social scientist. I'm not sure how many of you here would admit to being social scientists. Anybody apart from me? Yes, there are one or two. Excellent, okay. Okay, fantastic. And I direct a research unit based in the business school here at Cambridge, which has been in existence for over 20 years, which essentially involves collaboration across the disciplines, mostly between sociologists, economists and lawyers like me. One of the things we have been doing is creating new data sets on legal systems. I'm going to talk in a moment about how open access helped that, but it may be useful just to put the research into context for me to explain what it is we have been doing before we discuss the modalities of the open access. This is a data set we've created. It's one of many data sets which are online on the University of Cambridge's open repository. It can be viewed. What does a data set do? It consists of data which code for changes in the content of laws affecting business firms over a period of time in a large number of countries. So we have data on the laws affecting employment rights and shareholder rights, and what we're interested in is how these laws interact with economic outcome variables, or maybe how the laws themselves are affected by industrial or financial structure. What's the hypothesis or the issue that we want to examine? I'll come back to him in a minute. Research questions. We want to study what the impact of labour laws is on economies. It's a very contentious and politically contested area. On the one hand, the World Bank a few years ago said labour rights harm economies and they distort market outcomes. They burden firms and produce unemployment. That's a view that's perhaps dominated the policy debate in many countries over the past 30 years and is associated with the so-called Washington Consensus. More recently, the World Bank has changed its mind and said that actually advances in theory and empirical evidence suggest that labour rights deal with market failures, promote social cohesion, may be useful for all sorts of other reasons. The Nobel laureate Oliver Hart, the Nobel Prize this year, was awarded to a contract theorist who's argued this. So the debate shifts, but we're interested really in the empirical questions. How would you test this hypothesis? And now we're aware that not all things can be measured. Now, Einstein probably didn't say, I gather, not everything that counts can be counted and not everything that can be counted counts, but he should have said that because it's a very interesting thing to say. We know that many aspects of legal rules can't really be counted. And there are many aspects of legal systems which really count, which we'll never be able to measure. Right, okay. But as social scientists, which we hope we are, we understand that if we can't measure something, it may be very difficult to analyse it, very difficult to get a grip on it. We don't just do quantitative research. We also do what social scientists call multiple methods research. So field work, survey work, face-to-face interviewing, qualitative work. This is all very important to us. But also important is data analysis. So we have to try and measure something which is probably very hard to measure, how far a legal system protects or doesn't protect workers. And we gave the name Leximetrics to this emerging body of work, which was a bit presumptive. We weren't exactly the first people to use this word, but the word has sort of caught on to describe what we're trying to do. Now I'm going to try and escape from PowerPoint, because I'm sure you all think it's a good idea, because I gather scientists don't use PowerPoint much these days, and go to Chrome, if I can. I can show you the coding template. So this is not very complicated. We're using a form of content analysis to take legal texts, which we can retrieve online. This is not field work. This really can be done in the ivory tower, back at Cambridge, back at base. We may occasionally go to a law library that has texts we can't otherwise access, but essentially we can access the texts online. It's a little bit difficult to download some of these materials or to get at them. You may think that we know what the law is in a given country, you may think this is obvious, and lawyers know this, but actually, if we're coding back to 1970, it's harder than you might imagine to find out what the law is in a given country at that point. I know what the labour law of the UK was in 1970. I'm not quite old enough to have studied it then, but I know what it is and I know where to look for it. But actually old statutes, old materials are generally thrown away because law firms today don't really need them, and often libraries don't have them either. So it isn't completely straightforward to track this down, but having tracked the text down, we then develop a so-called coding template, which is just a kind of verbal algorithm to try to take a legal text and put it into a numerical form. So we're coding for a law and giving it a value. It's a so-called synthetic index. There is a methodology around this. It's recognized to be more art than science, perhaps. But these indices are widely used, not just by academic researchers, but also by the World Bank, by the OECD, and by other organizations. So it is a methodology which is familiar to some extent to people working in the field, but there are major shortcomings, and this goes to the issue about replicability. Many early researchers, including those supported by the World Bank, didn't very transparently publish their coding template, nor did they very clearly publish the underlying data. So there are data sets online which are alternatives to ours, but it's very difficult to use them to find out what's going on. Now, what do we get at the end of the day? We're getting, here we are. Oh, we're not quite there. Okay, we'll try again. Right, okay. So if you go online to the University of Cambridge repository, you'll see an Excel spreadsheet with years and data. This is one country out of over 100. We have 40 plus years of data, and we have 40 indicators. The individual indicators try to capture the content of labour law rules. We try to present this as straightforwardly as possible. A researcher can use the Excel spreadsheet in any way they want. They can combine the data in different ways. There's a huge issue around weighting of data and aggregation of data of this sort. But the way the data are presented, year by year, indicator by indicator, country by country, leaves it very much up to third parties. They can use the data in different ways. Many other researchers just publish quinquennial data, don't break them down indicator by indicator, to show an average. We've tried to make this as usable as possible. Not rocket science, but we hope it's still useful. To go back to the PowerPoint, okay, F5, should get me back in a minute. What were the difficulties involved in making this data open access? So I'll skip over a few slides. I might just show this one actually, that's where this is topical. Expertise. Experts have come under real challenge in this country over the past few months, I would suggest, and maybe elsewhere. I think it's very important if you pretend to have expertise, especially in an area like this, which is very politically contentious, and where we're using contentious methodologies not everybody accepts, to be as transparent as possible. Transparency of the data has been our goal. I think there's a lot of modelling and a lot of data work in the social sciences which is not transparent at all. And the issues raised in the earlier talk about replicability and reproducibility absolutely apply even more strongly to the social sciences than they do to some of the other sciences. So transparency is an absolutely critical issue for our democracy and not just for methodology. What were the problems we encountered? I'll skip over that. I was happy to talk about this data in more detail if you want to examine it with me later. But what were the problems over making it openly available? So we were funded by the Economic and Social Research Council, the UK research council that funds social science research, beginning in about 2005 to do this work. We didn't get it all done straight away. There have been successive waves of funding to get us to this point of coding so many countries in that way. The ESRC requires data to be archived at the end of the project. So we always knew that the data would have to be made publicly available at some point. There was therefore no real point to concealing it. However, the end of project archiving doesn't always lead to data that are easily usable, I guess. If you go to the UK Data Service Archive, the Essex University Archive, lots and lots of social science data are deposited there. Usage rates are quite low, I think, because the data may be difficult to use. If you didn't create the data, it's very hard to understand how to use it. This point's already been made, I think. Not just within one lab or one group. We hope we can explain to our own team members how we used or created the data. But obviously third parties may find it not very accessible. In our group, in our unit, we have in the past created huge data sets which are of national importance, which were not made generally available straight away. Now, the trade-off there, I wasn't involved in this project, but the trade-off is, if the data are not made available, the original research team can use them, before other people do, and will get the critical publications. Economics is like any other field in this sense. There are certain journals which are singled out as being so-called core journals. I don't like that, I don't really accept it, but that's the reality that we have to live with. Getting those papers into the top journals was a priority for everybody in the research group, but the data were not made generally available and were not used consistently. That has a downside, and maybe those papers were not cited sufficiently as a result, and the data weren't being used. When we came to do this Leximetric data coding, we took a decision to do the opposite, that we'd make the data available on our own CBR website here in Cambridge from a very early stage. So although what I've just shown you is a new set of datasets greatly expanded, the original datasets were put online from about 2008. People began to download them. So recently we did a count and we found that there were 50 or so studies where people had not just cited but actually used the data. They'd used our approach. That's very encouraging. This wouldn't have happened if the data had not been made publicly available. So the upside of open access is, I think, more citation of the data, greater use of the data, and the papers connected to the data will themselves be cited. So that if you think that getting cited is important, and I think it is at some level, this is very useful to us. Now, I think, however, there are benefits and costs associated with open access. The benefits, of course, don't just include citation, as the slide shows, they also include improving the data. The data we put online, if you can imagine what we're doing, there are 3 or 4 people working in a team, they're collating all this data, all this legal stuff, coding it. Right? It's very, very labour-intensive and tortuous and laborious, complex process of iterating between 2 and 3 people to try to get the data, the values, as accurate as we can make them. Now, having said that, lawyers disagree on nearly everything. And one of the things we disagree with each other on would be the codings for the different countries. One way to do it that we didn't do, we could have had over 100 experts. One country, one expert, they do the coding. There are methodological problems with this because quite often the coding algorithm isn't applied consistently by so-called national experts. They know the law, but they don't exactly know what we were thinking of when we coded or developed the coding template, because these things are complicated. And we don't have money to employ 100 people to do this for us. Lawyers normally charge fees for what they do, whether they're academic lawyers or practicing lawyers. They rarely work completely for free. So we took a decision to do most of the coding ourselves. Even though this did require accessing texts in the original language, between us, we probably spoke about 5 or 6 or 7 languages. There were some languages where we did need help there. We would go to a national expert. And sometimes the law in Hungary in 1995 or in Finland in 1970 is very difficult to retrieve, let alone language problems of those 2 particular countries. Very few people do speak Hungarian and Finnish. We thought we'd covered everything, but of course once the data set began to be published, then researchers would email us and say, you've coded that wrongly. Okay, now that's useful because it means that we can improve the data as we go along, and that's bound to happen. So we're going to improve the data, we'll get feedback, eventually it'll be better, and of course we're also getting feedback all the time about the methodology. What's the downside? My final point. Okay, there is a downside to this, okay, and the scooping is a real problem. Okay, so let me give a couple of illustrations of this. Our coding template has been reused by several other research teams. Okay, so they took our methodology and reused it and did their own data analysis. At one level that's very encouraging, but some of these teams are prone to say that the data are theirs. Now, maybe the data are theirs, they coded somewhat differently, but the template is ours. That coding template is often used without attribution. That's a major issue, and sometimes those teams don't cite our work. Right, okay. So again, to take one particular case, one of our data sets, I had a few years ago an approach from US researchers in a leading US business school said, we'd quite like to work with you, and we see you've only got so far with coding countries for this other data set. Why don't we work together and do something? We had a preliminary discussion, it went nowhere. About 5 years later, I understood or learned that what they had done was taken our template, recode the data, even for countries we'd already coded, and extended it to further countries, published a paper in a top management journal, minimal attribution to our work. They basically said, okay, we have a list here of laws which we've coded. This was in fact our template, our own methodology, not the raw material. That paper was published in a leading management journal, barely any citation to our work. Now, our field is very segmented. I'm an academic lawyer. I work a lot with economists. Nobody in the law or economics fields would be confused about where that methodology came from. They'd all recognize it as ours. Management studies, and our unit is based in a business school, is somewhat different. Okay, so this is somewhat complicated. Now, at the end of the day, my view about this process is it doesn't really matter because they took our research, they took our insights to a large extent, they did something with it that we hadn't done at that point. That's fine. They used the research. There was a publication coming out of it. Okay, these things happen in academic life. I'm a senior researcher. I don't greatly worry about this. And at the end of the day, I got over it. Okay. But I think it is a real issue, especially for early career researchers, and maybe researchers in different fields. How will research be used in an open access setting? I think I'm just about out of time, so I'll stop there and invite questions. Thank you very much. Yeah.